Hello, and welcome to the Washington State Intergovernmental Case Processing Grant presentation, where fostering international relationships creates greater outcomes for families. My name is Christina Blessai Hayes, and I am the grant manager for the state of Washington over this grant. And a bit of a disclaimer before we get started here. COVID certainly had an impact on this project throughout all of the phases, frankly. We did see that reflected in lower referral numbers, as well as certain courts and agencies participating in our project being closed throughout at various points. Also, the population size for the Canadian and Mexican cases in the state of Washington is fairly small relative to the large case universe that we hold. Overall, with continued reduction in the child support caseload nationwide, we have seen that duplicated in our own case universe as well. A bit of a pre-intervention breakdown. As I stated before, here in Washington State, we hold approximately 300,000 cases in our case universe. We currently serve Hague Convention countries, foreign reciprocating countries, and non-reciprocating countries amongst those cases. We currently have no formal agreements with either the province of Quebec or any specific states within Mexico. 1% of our intergovernmental cases are considered international, and of those, the vast majority are with British Columbia, our partner to the north. Cases are assigned randomly throughout the state of Washington and can be assigned to any one of our caseworkers throughout the field. We currently hold 29 responding cases with Mexico and have no initiating cases to any jurisdiction. A bit of a summary on our Envision session held at the beginning of our project. We gathered caseworkers from throughout the field, as well as management in charge of policy and other various sections in our division. And what we found were we had motivated, engaged, and eager staff to participate in this particular project. They all had various levels of comfort with working international cases specifically, but also general UIFSA United States referrals. We had recognized that there were delays in compiling UIFSA paperwork as a part of that referral process. There was a lack of an awareness amongst caseworkers for those resources that are currently available. There was certainly unshared knowledge across the field. And part of the reason for that being is because the cases are assigned randomly, you may see caseworkers having more experience with certain jurisdictions than others, just simply by the assignment. We also recognize that we had out-of-date processes due to changes in not only the Hague Convention, but also the UIFSA processes. As we worked through the Envision session, what we came to find is that there were general activities which centered around 7 specific areas. We identified those as our areas for implementation activities. We had our first as international liaisons, project support and training, communications, analysis of policy, procedures, and resources, support enforcement management system, SEMS, enhancements. This is our own internal caseworker system, Canadian provinces specific, Mexican state specific. And I will provide you with a bit more detail around each of these. Our first intervention was our international liaisons, and this was certainly our largest intervention that was launched. This particular area was made up of 12 support enforcement officers, or SEOs, which are our caseworkers in the state of Washington. These individuals held 40 segmented specialized cases, which were assigned to them, made up entirely of those cases initiating and responding from Canadian provinces and territories, as well as the 29 responding jurisdiction cases to Mexico. In addition, we also had dedicated central services staff in order to make sure we had an entire encompassing of the case process to include case setup as well. We also conducted full case audits. Each of these caseworkers went through all of their assigned cases and reviewed multiple areas. We also held meetings with experts. We did contract with Public Knowledge as a part of this grant. Ultimately, they provided specific experts in the areas of Canada and Mexico, and we met with them on a generally regular basis. We also held internal monthly meetings with each other. This created greater comfort with working with one another. Direct intergovernmental policy contact, which was Thomas Atkinson for this particular project, who assisted in providing legal expertise. Reduction in workload. Each one of the offices where these caseworkers were stationed out of handled this differently. And it also provided a channel to and from local office management back to headquarters. A little bit of the observations we made surrounding our intervention for international liaisons. What we recognized was that we had a necessity to evaluate both qualitative and quantitative data for this. We realized that due to the small population size that we were dealing with Canadian and Mexican cases, we would also need to rely on the feedback and response from our actual caseworkers, essentially gathering that qualitative data through interviews and surveys. There were also recognized limitations of available metrics, and that specifically was around the fact that we have no current data fields specifically related to international caseload management. We also had feedback gathered, which emphasized the individual benefits. Depending on different caseworkers' comfort level, they sought benefit from various certain materials we made and technical assistance documents which we created for them. Some saw greater value in others. We also had recurring liaison meetings, which were expressed to be one of the most beneficial elements of this particular intervention. Again, this creating the space with staff to discuss case-specific issues and challenges that they face throughout the project, and again, creating greater comfort with each other discussing those challenges. Some of the feedback we received as a part of the first intervention from our surveys really highlights the area of fear and apprehension that caseworkers felt initially. Ultimately, it did move into a greater level of comfort as they worked through various case scenarios. By the end, you can see the project was so amazing, and I can only hope that you make the recommendation that all international cases should be specialized. It's just more efficient. You can see that these caseworkers did come to a greater comfort and ultimate excitement about the potential of future scaling. Our second intervention centered around project support and specialized training. We did seek that specialized training, again, from our contractor, Public Knowledge, who provided training on Canada, Mexico, as well as multiple other case-specific topics dedicated to issues and challenges that the caseworkers faced. The activities centered around liaison-driven topics, process flow documents, written instructions for multiple processes depending on the jurisdiction, age of majority tables, and interest enforcement are just some of them. Some of the observations, and evaluation around these are the value in reviewing challenging concepts with experts. We certainly heard back loud and clear from our caseworkers that running case-specific issues and challenges past our experts was most beneficial as a group. They were able to learn from each other's challenges and hurdles. We also recognized that there was a lack of training on changes that had been made as a part of the adoption of UIFSA and Hague policy into our handbook. We also recognized that our available resources were limited for specific Canadian provinces and territories. And again, part of that was based on the infrequency with working with some of the provinces and territories. We also recognized that there were benefits to providing technical assistance documents in multiple formats. Part of the reason for this being is some staff felt the process flow documents were most helpful visually as they worked through the referral gathering process. They also found that directions provided specifically for jurisdictions were useful to walk through sequentially. Intervention 3 really surrounded around communication with our partners. So again, for this project, this was mainly focusing on Canada and Mexico. What we recognized was we faced barriers based on COVID. Many partners were sent home to work, as well as Washington State. This made communications additionally challenging. There was a lack of process documentation. As far as a current state process documentation process, we didn't have any. We had policy contacts in our own policy unit which were unfamiliar with how we were developing communication contacts in other jurisdictions that had pre-existed their area of expertise. We also had points of contact that were not documented. So again, we did not know necessarily who to reach out to specifically. All Mexican officials were working from home due to the pandemic. This also created additional challenges, which were significant for our contracted expert. They had to venture out into the Mexican states, which we targeted, to identify specific individuals to continue contact, which was, again, a challenge due to COVID. Seattle's Mexican consulate was also closed to in-person appointments. This impacted the project in that we were unable to successfully contact an individual within the consulate for quite some time. We also were looking to investigate electronic communication options, which might be available for our partners. Some of what we observed in this intervention were that there was a great necessity for updated process workflows, and those were created based upon our work as far as developing what the current state was versus what caseworkers would prefer. Our policy specialist developed a shared repository. This was a possible solution to the issue which he faced in identifying contacts and process development documentation previously when trying to contact Mexico as well as Canadian jurisdictions. Also, expert knowledge and contacts were extremely useful. Again, without the assistance of the experts from our vendors, it would have been extremely difficult to actually make contact with the appropriate individuals in order to discuss collaboration events. Our Area 4 intervention specifically was around analysis of our current policy, procedures, and resources. As a part of that, our vendor, as well as our policy unit, performed a gap analysis in order to determine where the potential challenges and hangups were in our current process. We also identified currency conversion as an area that needed to become a bit more robust within our handbook. We worked towards process development around that topic. Also, providing guidance as needed. So certainly we recognize the necessity to provide policy guidance as early as possible when there were issues that arose legally within the process of referring a case. The evaluation around this intervention really recognized the need and the benefit of having our policy unit involved. They were able to partner with our vendor, Public Knowledge, in order to determine resolutions to possible conversion challenges. This was by far the most frequent issue which our caseworkers faced amongst all of the jurisdictions. What it ultimately revealed is that we have additional issues with processing international payments themselves. And as a part of this, has identified additional work that our Central Registry will continue to work on as we move forward in supporting OCSE and developing a national approach to payment processing. Common conversion themes were addressed with the largest Canadian partners. Again, British Columbia being our largest province was one that we specifically identified to review case-specific challenges around conversion. Intervention Area 5. This specifically was addressing system enhancements or the potential of. Our system is a legacy system, and we do find challenges from time to time with current and available data fields, which we are able to utilize for analysis purposes. This is a particular challenge for international cases. Some of the suggestions that came up as a part of our Envision session with staff, as well as with policy, were that there was a need for alerts of timeframes specific to international cases. Those can vary between Hague Convention countries or foreign reciprocating countries, as far as service dates, which may have been 30 days, are elongated to 60 days based on the fact that you're dealing with an international body. Staff admitted to missing some of those timeframes based on the lack of understanding on working with an international partner. Also, alerts for annual balance reconciliation, updated currency conversion. Folks were wanting and requesting strongly that there be some sort of designation within our system in order to alert them to the fact that a reconciliation or an updated calculation was needed in order to convert currency. They also requested flagging international mail for additional postage. There are times where, based on the limitation of our address fields, we are unable to automatically add enough postage in our mailing system. That creates additional work for our central services staff. So it was central services that had identified as this being significant for them. We also looked at reformatting the address screen to accept foreign addresses, as well as adding an indicator for the type of international referral. Again, to align with dates as far as specific to international cases, which were either Hague Convention, foreign reciprocating, or non-foreign reciprocating bodies. What became readily apparent as we worked with our partners in the IT department was that ultimately reviewing the existing enhancements request would assist us most, based on the fact that they have a large workload ahead of them due to COVID issues and challenges around technology. We knew that we would need to make it as efficient for them as possible. So we looked for and attempted to identify those requests which had already been made for similar sorts of enhancements so that we could align with those and potentially build off of them. We also recognized during conversations that the cost versus the benefit was considered fairly high based on the fact that the international caseload is so small. This creates a challenge in order to develop work hour allocation for IT. We also realized that we were going to need to capitalize on alternatives. So we worked and partnered with IT to determine different areas that we could create workarounds, which may actually achieve the goal, but ultimately not change the programming. Intervention Area 6 really focused on our Canadian partners. The Canadian provinces which we targeted for this particular project were British Columbia, Alberta, and Ontario. We ultimately held 3 events with British Columbia. This was with management as well as cross-training with their staff. We also held an initial collaboration event with Ontario, with more of those scheduled in the future. Creation of province-specific technical assistance documents was highlighted as something that the support enforcement officers felt was critical. Currently, what we have available as resources were really specific and ultimately highly limiting. Also, we were looking to gain access to the British Columbia Family Maintenance and Enforcement Program portal. This specific portal would allow us to communicate freely with the caseworkers in British Columbia, making communication more efficient between the 2 countries. So some of the things that we observed as far as our evaluation with this particular intervention and the activities surrounding that were that the largest benefits centered around increased communication and training. We were able to identify specific contacts and supervisors of those caseworker contacts in the various provinces. We also had access to electronic messaging, as I stated before, with the British Columbia portal system, and that has been immensely helpful to our caseworkers as well as to the caseworkers in British Columbia. We also recognized and were able to clarify terminology, which both countries used, which was actually creating misunderstandings as communication moved forward. We also gained greater understanding of province-specific processes. So all too often, I think Canada in our state was somewhat lumped as one, without recognizing the various legalities and specifics for each jurisdiction when you're dealing with 13 provinces and territories. This created greater help for us as far as being able to communicate easily with various jurisdictions to understand their specifics. Resources also address a variety of learning styles. The technical assistance documents which were created were beneficial for both Washington and British Columbia, as many of them identified a flow for process for each jurisdiction. As a part of our interventions and our activities around the Mexican states, we did a deep dive as far as a pre-intervention evaluation. We were looking at a very significantly small population, again, currently only 29 cases. Currently, Washington had only been accepting establishment referrals only. Many of those referrals would then move on to a full enforcement case. However, they started out requesting that based on a paternity affidavit, which was filed within the state of Washington, we would then be able to establish an order on their behalf. Most of those cases were funneled through the Mexican consulate in Seattle. However, when there were challenges faced with either payment processing or communication, the burden fell primarily to the custodial parent to remediate those issues. That created greater challenge and miscommunication amongst the various parties. The main goal was to establish a bilateral agreement, which would encompass all the more than 30 Mexican states. We ultimately determined, based on our limited time, that we would need to identify primary targeted states. As we looked through our current caseload, there were no highlighted states, which we saw repeated frequently as far as the referrals. We determined at this point that our best approach would be to find those states which would align the border. This would make sense, as hopefully more referrals would be received from individuals moving back and forth potentially. We ultimately determined that we would partner with Baja Norte, Sonora, Nuevo León, and Coahuila, Mexico. We developed, as a part of the collaboration, process guides and reference materials for each of those states. Initial observations around this. Many of our activities continue as we speak. The challenges were, at times, seemingly insurmountable. Again, with the issues with COVID, that put an additional issue for each problem. Multiple stakeholders were involved throughout the process. As I mentioned, we were working with not only the consulate within Seattle, but ultimately with the Mexican Central Authority. This is the overarching government, which does dictate some legalities for each state as far as entering into partnerships. The Mexican Central Authority had also announced their intent to sign on to the Hague Convention themselves. This is something that the Mexican Central Authority has been messaging for some time, however, ultimately has not made or set a specific date for that. We also identified IT security concerns around the sharing of data, personal data on each of the cases. We also recognized liability concerns. If we had our director in the state of Washington sign an agreement without knowing that the other party might sign it, there could be challenges moving forward and potentially using that agreement in the future. As a part of all of these activities, Washington State thought very hard about what our recommendations would be submitted to our leadership. What we ultimately found, again, based on the surveying of our staff involved with the project, was that they really found the benefit to specializing these cases. They will ultimately serve, moving forward, as the subject matter expert within their offices. We would want them to have expanded access for international calling, be granted access to the British Columbia Family Maintenance Enforcement Program portal, participating in recurring meetings, again, to build that shared knowledge amongst each other, and engaging in ongoing collaborative calls with our Canadian provinces and territories that we've made connection with so far. Also, as a part of our recommendation packet, we suggested that inclusion of the suggested edits by our vendor public knowledge pertaining to the 2007 Hague Convention, as well as additional updated OCSE information memorandums and OCSE action transmittals be incorporated as a part of our policy handbook. As a part of this submission, I am happy to say that our leadership team did adopt both of our recommendations wholeheartedly and are very supportive of continuing the work, scaling, and phasing of this project. As a part of our next steps, we intend to publish all of the technical assistance documents, almost close to 30 of those, on our intergovernmental SharePoint. We also will be moving forward with moving the activities pertaining to this project to a sustainable situation with our policy unit. We are currently in the process of transitioning all of the activities, and policy will be taking over. We plan to continue moving forward with our efforts in order to establish an agreed upon arrangement with our targeted Mexican states, but also leaving ourselves open to continuing to pursue additional agreements. And finally, we would like to continue supporting the partnership and communication with the Mexican consulate. They have proven extremely valuable and most helpful as we've worked through and navigated the processes with Mexico. That is the presentation today for Washington State's Intergovernmental Case Processing Grant. Again, my name is Christina Blessi-Hayes, and I have posted my email below. Should you have any questions or would like to speak with me, I encourage you, and I appreciate the time you've taken to listen to this webinar today. Thank you.